So welcome everyone to my SIP, Discrimination and the Law. Before we get started into the presentation itself, I wanted to make sure to do a land acknowledgement. This is a statement that's been adopted from the UCSD Intertribal Resource Center. UC San Diego holds great respect for the land and original people of the area where our campus is located. The university was built on the unceded territory of the Kumeyaay Nation. Today, the Kumeyaay people continue to maintain their political sovereignty and cultural traditions as vital members of the San Diego community. We are honored to share this space with them, and we thank them for their stewardship. I also wanted to introduce myself. My name is Risa Salino. I use she, her pronouns, and I am an outreach and engagement intern and social justice educator at the Cross Cultural Center. I'm also a political science public law major, which is why the topic of my SIP has to do with the law. So this is an overview of what we'll be going over today. We're going to start off by talking about employment discrimination in general. So I'll go over a bit of what employment discrimination is, how employment discrimination cases work in the US legal system, that sort of thing. And then we'll move on to success rates in employment discrimination cases and look at trends there. And then I'm going to be moving into different causes as to why we might see lower rates of success in employment discrimination cases. So the four main ones I'm going to be looking at are the language of anti-discrimination laws, the legal process, so how anti-discrimination claims are brought. And then I'll also be looking at judges, so the roles that judges play in affecting the outcome of cases. And finally, I'll look at the system, so how the legal system works against affected groups. We'll start off by looking at employment discrimination in general. And I wanted to pose a question to y'all, which is, what is your understanding of discrimination? I'd love to hear just how you understand it as of right now. All right, someone in the chat said, discrimination is the physical embodiment of prejudice, so the actual actions. I think that's a good way to think about it. And later in the presentation, I'll be talking about why discrimination occurs and the role that prejudice plays, absolutely. So this is the definition that I found and came up with for discrimination, specifically employment discrimination. And this is when an employee is treated differently or less favorably based on a personal characteristic or identity, such as race, sex, religion, national origin, disability, and age. And of course, people can be discriminated against for identities and characteristics that are not listed here, but the ones listed are the identities that are covered under the law. I also want to go into a few examples of when employment discrimination can occur, because I think oftentimes it's thought of that employment discrimination is only actions that are taken when someone is working in a certain place, but that's not necessarily the case, and it can occur throughout all parts of employment. So one example of this is not getting fair consideration in the hiring process. For example, people with non-white sounding names may be discriminated against in the hiring process. There have been studies that have shown that people whose names don't sound white tend to have less success in getting interviews than those whose names sound more white. Additionally, it can look like inappropriate comments or harassment. For example, coworkers or your boss might say something inappropriate, something racist or sexist or otherwise hurtful that's based on one of those categories that I mentioned earlier. Another way that employment discrimination can look is being passed over for promotions. So people in marginalized groups sometimes don't get the position that they deserve just because of their identity. So although they may be able to get the job, they're not able to move up within the company, for example. And finally, this can look like being fired because of your identity. Sometimes this is explicitly told to you, and other times it's not so explicit. For example, let's say you brought your spouse who's the same gender as you into work, and then the next week your boss fires you. Although they may not have explicitly said that the reason they fired you is because of sexuality, this can be inferred. So to get a better understanding of employment discrimination and discrimination in general, we're going to look a bit at why discrimination happens. And I think the biggest reason for discrimination is due to prejudice and because of what I'm calling the isms. So racism, sexism, heterosexism, ableism, basically discrimination that's based on things like race, sex, sexuality, and ability. And sometimes this prejudice is really outright or explicit. The person who's enacting the prejudice understands that their prejudice and the actions that they're taking are very obvious. But oftentimes discrimination is due to something called implicit bias. Implicit bias is people acting on the basis of bias or stereotypes without meaning to. So they do it unconsciously, but with racist, sexist, or other bigoted ideas as the basis for their actions. And oftentimes these actions are less overt, less obvious, but still have very harmful effects. And so when we're looking at employment, there are three aspects in the cognitive bias process that play a role. And these are stereotyping, attribution errors, and in-group bias. So when I'm talking about in-group or in-group members, these are people who are in the privileged group, not the ones in the marginalized or the affected groups. So for stereotyping, this can look like applying characteristics traditionally and often inaccurately thought of as belonging to a group to all members of that group. For example, if you hold the belief that women are emotional, you may not hire a woman because you think she can't make a rational decision because of this trait of being emotional. Another one of these is attribution errors. So this looks like attributing the success of in-group members to their talents and lessening or altogether ignoring failures. On the other hand, for people in the marginalized group, this looks like attributing the success to luck or to the efforts of someone else, such as an in-group member, and fixating on the mistakes of out-group members, seeing them as a personal or a group failure, such as a lack of skill or a lack of effort. And finally, we have in-group bias, which is that people tend to prefer others who are of their same social group, and this can translate into the workplace. So if you have a white male boss, he may be more inclined to hire white men because people tend to prefer those who are similar to themselves. And although a lot of progress has been made in terms of discrimination and prejudice ideas, discrimination is still a huge issue in the workplace. Looking at race, a 2017 study from the Harvard Business Review of racial discrimination in hiring showed that the callback for Black applicants relative to white applicants has changed very minimally since 1990. So there's been very little change in discrimination in the workplace, and we can still see that there's this gap between Black applicants and white applicants in hiring. This same discrimination holds true for gender. A 2017 study done by the Pew Research Center on sex-based workplace discrimination showed that 4 in 10 working women say they've experienced gender discrimination at work. And so we can see, just based on race and sex here, that there's still a significant problem with workplace discrimination. I'd also like to note that I'll be referencing some data throughout this presentation, and all of this research and these studies were done from a binary point of view and from the point of view of people with privilege and those in power. So that's just something to keep in mind when we're looking at these statistics. All right, so now we're going to go ahead and move on to the problem. So looking at employment discrimination cases and their rates of success. Before we get into those statistics, I wanted to show this video. It's called "The Truth About Discrimination in the Workplace" from Dr. Kali Hussein. And she talks about the lived reality of facing discrimination in the workplace and how it's dealt with. So I'll get into the legal issues with discrimination cases later in the presentation, but I first wanted to offer a sort of explanation about discrimination, as well as the issues with finding legal remedy from someone who's experienced workplace discrimination. The full video is around 15 minutes long, but I'll be playing a clip that's about 3 minutes long.
So what protections are there in the workplace for those who experience discrimination? So in the US, we have the Equal Opportunity Employment Commission, which is a large federal agency established via the 1964 Civil Rights Act to help administer and enforce civil rights laws against workplace discrimination. We also have the Age Discrimination in Employment Act, as well as the Americans with Disabilities Act. But in reality, despite all these protections, discrimination still exists. And this is why I wanted to talk about the truth about discrimination in the workplace, even with all the protections in place from a legal standpoint, the fact that there are laws against specific things. I'll give you a couple of examples. When you're in an interview, it's illegal for employers to ask you about your marital status or whether you're planning on having children or not as a woman. It's illegal for employers to ask you about your religion. There's a lot of discrimination when it comes to wearing the hijab in many fields. In medicine, I've experienced it myself where I was asked to take off my hijab. From a legal standpoint, it is absolutely illegal. But for someone who is looking for training or looking for a job, especially that early in your career, it becomes very difficult to go the route of legal recourse because a lot of these communities, a lot of these fields are very close-knit and everybody knows each other. So when you go that route and you speak up, it is possible for you to experience retaliation, which can take the form of being blackballed from your field. So that is the reality of discrimination in the workplace. Is yes, there are protections in place from a legal standpoint, but the reality is that all those protections are violated, all those civil rights are violated very frequently, and speaking up and reporting all these experiences, even with the structures in place, even with a federal agency in place, is less helpful to the employee. Or if it's a student or someone early in their career, it becomes very difficult to prove a case or to even have it go your way because a lot of these companies, as you can probably guess, are well equipped with big law firms. And I have been told in the past when trying to advocate for a junior resident that someone that early in their career going up against these big corporations is similar to a goldfish going up against a shark. So this is the reality of discrimination in the workplace. Employees have rights, but those rights are violated very frequently. And the current protections that we have in place, our current avenues for recourse are not 100% without risk to the employee and very little risk to the companies, to the employers. And even when they do end up having to pay a fine, it's a small fraction of their worth.
So now we'll go ahead and move on to looking at successful discrimination claims and the rates of success in discrimination claims. So I have a graph on the left here that shows the total number of discrimination claims through those blue bars from 1992 to 2020. And then we have this red line at the bottom there, the dark red line shows the number of successful claims. So right off the bat, we can see that there's a very significant gap between the total number of claims and the number of successful claims. But also, if we look over time, looking at that light red line on the bottom, the straight one, this shows the trend in successful discrimination claims. And we can see from this line that there's been very little change in the number of successful discrimination claims over time. Since 1992, there have been only approximately 22 more successful cases per year, which is an increase of around 0.07% per year. So very minimal change over time. And then if we move into looking at the proportion of successful discrimination claims, so comparing the number of successful claims to the total number of claims, we can also see that there's been very minimal change from that light blue line. The proportion of successful discrimination claims has only increased by 0.02% since 1992. And besides that sharp increase between 1996 and 2000, you can actually see that generally, the proportion of successful discrimination claims has been decreasing over time. This holds true for claims based on sex, although it's slightly better. Again, this is the same blue bars showing total discrimination claims, and that dark red line shows the number of successful claims, while the light red line shows the trend in number of successful discrimination claims. So for sex-based discrimination claims, again, it's been overall more successful than general claims. We can see that it increases at an average of 43 more successful cases per year, but this still is only an increase of 0.17% per year, so very minimal change. And then if we look at claims based on race, again, we're seeing very minimal change. This mirrors almost exactly the trends that we see in overall discrimination claims. The number of successful discrimination claims has increased by less than 22 per year since 1992 for race. So in general, there's been very minimal change in the number of successful claims, and overall, looking at the proportion of successful claims, that is also very low and has seen very little change. So I wanted to pose another question to y'all, which is, why is it important to have success in discrimination cases? And why could it be harmful when we don't? All right, someone said it can help encourage others who are experiencing discrimination to speak up. I absolutely think that's the case. I think if you're seeing success in other people, speaking up against discrimination, if you face discrimination, that will make you want to do the same thing. Someone else said, because otherwise nothing gets done about discrimination. I think that's another good point. If there's no fight back against discrimination, these things can keep happening. And someone said it's discouraging if others are not successful. Absolutely. If you see someone not make progress or put all this time into filing a discrimination claim and then have no success, that makes it difficult for you to choose that route. Someone else said it makes it seem possible for change to occur. Absolutely. And it gives a platform and brings more attention to these issues. I totally agree. I think these are great reasons why it's important to work for success in discrimination. So now we'll be talking about the different causes of why we might see lower rates of success for discrimination claims. And these are the ones that I found in my research. These are just 4 possible causes. So we'll be starting off with language. And especially in law, language has a huge impact. How a law is written has so much influence on who it applies to, what it can do, how it's interpreted, all things that make the law what it is. So for example, if the language of a law is too specific, it won't apply to everyone or everything that it's meant to apply to or that it should apply to. But on the other hand, if language is too general, it might be vague or unclear and up to interpretation. Even punctuation makes a difference. For example, if we look at the Second Amendment, I think it has something like 4 or 5 commas, and those commas change the meaning of the amendment itself. So even something like adding a comma versus a period can absolutely change the meaning of a law. So to make this a little bit more concrete, I wanted to give an example of why language in law is so important. So let's say that I have a really good Thai dinner. I put the leftovers in my fridge and then my roommate takes them and I'm really upset about it. So I decide to make a law that says it's illegal to take your roommate's leftovers. Now, on its face, this seems like a really simple law. It's pretty easy to follow. Just don't take your roommate's leftovers. However, if we look at the specific language of the law, it can get a lot more complicated. For example, looking at the word take. Is take permanent? Can you take some of the food, eat it, and put the rest back in the fridge? What if I were to take the carry-out container to my room and bring it back without eating anything? Would that break the law? What does take mean in this context? And we can also look at the last word in that sentence, leftovers. So what's considered leftovers? Is it just takeout food, like food that you bought out somewhere at a restaurant? What if I cooked a really nice dinner and I put the rest of the food that I didn't eat in the fridge? Would that be considered leftovers? Or what if I ate part of an apple or half of an avocado and I were to put the rest in the fridge? Is that leftovers? Also, are there exceptions to this law? So what if I ask my roommate, hey, are you going to finish your pasta that's in the fridge? And she says, no, I'm not going to eat it. You go ahead. And would it still be breaking the law if I then eat the pasta? So it's really important to recognize that even for something as simple as it's illegal to take your roommate's leftovers, there can be lots of ambiguity and confusion in the language of the law. And again, this is a super simple example, so we can see how it can get super complex when we get to more complicated issues. So looking at a real life example, let's take a look at the Civil Rights Act of 1964. So this is one of the big laws in anti-discrimination, and Title VII of this law prohibits employment discrimination based on race, color, religion, sex, and national origin. Those are the same categories that I mentioned earlier. So on its face, again, this is a pretty simple law. Looking specifically at Title VII, it seems pretty clear what's prohibited. However, as history has shown us, this language can be ambiguous and up to judicial interpretation, as well as exclusionary. So looking at the Supreme Court case, Bostock v. Clayton County in 2020, this was a case, actually it was a few cases, one where an employee was fired for being gay, another in which an employee was fired for being transgender. And the question here was whether these things were protected under the sex part of Title VII of the Civil Rights Act. Are LGBTQ+ identities protected? Now, the Supreme Court ruled 5-2 that yes, these identities are protected under the Civil Rights Act of 1964. However, this case could have absolutely gone a different way with different judges. It was truly up to their discretion. So I think this case, although it was absolutely a win and something to celebrate, shows the fragility of these laws and additionally the power that judges hold, which we'll talk a little bit more about later. Another law that I wanted to look at was the Equal Pay Act of 1963. So this law prohibits sex-based wage discrimination between men and women who perform equal work in the same workplace. And now just right off the bat, it's clear that wage discrimination and pay disparities still exist. As of 2020, women make 82 cents to every dollar that a man makes, and this difference is even greater for women of color, especially Black, Latinx, and Indigenous women. Furthermore, in a 2017 survey by the Pew Research Center, 1 in 4 women, so a quarter of women, said they earned less than a man who was doing the same job. So it's clear that wage disparity still exists despite this Equal Pay Act. And I'm going to explore some of the reasons that might be. So if we look at the graph on the left there, that's showing average player compensation per sport in 2019. And we can see that there are huge pay disparities, especially looking at basketball and softball and baseball. And in every sport, men are paid more than women, oftentimes by a very large amount. Looking at softball and baseball, you can't even see the bar for women on the left there. I tried to make it as big as possible and it just wasn't visible because the pay disparity is that great. So the reason, or one of the reasons why the Equal Pay Act doesn't protect this is because this law says same workplace. So men and women who do the same job are not compensated the same way and can't claim unequal pay because they don't work in the same workplace. Now, recently, a couple days ago, actually, there was a really big win for women's soccer. The U.S. women's national team was able to gain equal pay and move in that direction, which is fantastic. But we still see pay disparity and discrimination across a variety of sports. Now, some other reasons why this pay disparity could exist is that women are often less likely to be represented in higher paying positions. And additionally, pregnancy and childbirth play a role. So even though pregnancy and childbirth are protected under the Pregnancy Discrimination Act, many women have to take time off for pregnancy and maternity leave. And additionally, because of social norms, they often take more time off than fathers. In a 2019 survey, mothers with children younger than 18 were more likely than fathers to say that they needed to reduce their work hours. They felt like they couldn't give their full effort at work, and they turned down a promotion because they were trying to balance work and parenting responsibilities. Now, the language of the Equal Pay Act isn't strong enough or comprehensive enough to cover all of these things that I've discussed. For example, maternity leave isn't covered. And because of that, the language of the law affects how it can come into play and how discrimination and anti-discrimination laws can be enacted. The next thing that we'll look at is the legal process. So how discrimination cases are brought and why this can affect their success. So another question for y'all, what do you know about the legal process in discrimination cases? Someone in the chat said very little. Absolutely fair. I didn't know much about this before doing the research. Oftentimes legal processes can be very complicated and very difficult to understand. Someone else said it has many steps. Absolutely. There's lots of different pieces to bringing discrimination claims. And I'll go ahead and move on to the next slide, and I'll start breaking down how discrimination cases can proceed. Oh, sorry. One more answer in the chat that I'll go ahead and read. Someone says, I think there have been systems created, so make sure discrimination claims are independent of employers or internal superiors. Have to be able to afford a lawyer and comfortable speaking out. And those are all great points. Thank you so much for your answers. So as I mentioned, this is a very complicated process, and I'll be breaking it down and putting it in as simple terms as possible so it's easy to understand. So there are two main types of discrimination cases. These are disparate impact and disparate treatment. Disparate impact cases are when workplace policies are neutral, but they have a discriminatory effect. So an example of this is a policy in the workplace that only allows certain hairstyles. Now, although this is neutral at face value, it discriminates against people with different hair textures. For example, it's very common for hairstyles worn by Black people to be called unprofessional. And so although a rule that only allows certain hairstyles may seem neutral, it actually has discriminatory effects. So this would be an example of a disparate impact case. The other type of case is a disparate treatment case. And this is when workplace policies or incidents are intentionally discriminatory. So an example of this could be a boss making a rule that same-sex couples are not allowed at office parties. Now, when you're trying to prove discrimination, there are, again, two main ways that you can do this: the direct route and the indirect or the pretext route. So the direct route is to provide direct evidence of discrimination. So I don't know, maybe your boss sends you an email and tells you you're fired because you brought your same-sex partner into work and he doesn't like the fact that you're gay. Now, this is a very obvious and explicit example, and this might not happen in the real world, but this is an example of, direct evidence. that it's clear that there's overwhelming evidence of discrimination. Now, oftentimes this is difficult to get, so many people choose to go the indirect or the pretext route. And this route has three main parts. The first is that the employee has to show some evidence of discrimination. This is called in the legal field prima facie evidence. So some evidence that discrimination has occurred, but it doesn't have to meet the burden of proof, which I'll talk about in just a second. So just show some evidence. Then we go to the employer. And so after the employee has showed some evidence of discrimination, the employer has to show a legitimate reason for that discrimination. They have to provide a business or workplace reason as to why that discrimination occurred. And once they do that, then we go back to the employee, and the employee has to prove that this reason is invalid or not applicable. So I mentioned the burden of proof, and I want to explain what that is because it's super important in the legal field and especially in cases like these. So the burden of proof in all legal cases rests on the person that's bringing the claim. So in this case, it would be the employee, also called the plaintiff. And in civil cases like these ones, the burden of proof is what's called a preponderance of the evidence. And this is just a fancy legal way of saying more likely than not. So if you think about those scales in the middle, more likely than not means that one side is just slightly higher than the other. It's more likely than not that discrimination occurred. Now, the burden of proof matters because oftentimes the burden of proof matters because it does favor the employer, and oftentimes they have to do very little to dismiss the case. So in the case of a direct route, it can be really difficult for employees to get concrete evidence of discrimination and to meet this burden of proof. However, if employees choose to go the indirect route, employers just have to produce a reason for discrimination, regardless of how absurd this reason may be. The Supreme Court has ruled that there's a very low bar for providing this reason. Essentially, as long as they say something, as long as they provide a reason, the burden of proof shifts back to the employee to prove this discrimination. So I wanted to give an example of how the legal process can work against people in the real world, because a lot of this is pretty abstract and a lot of different legal terms. So we're going to look at the case of Jason JESSUP. And this was a man who faced discrimination at his job at UPS. Specifically, he faced racial discrimination. And other Black UPS drivers said that they experienced similar things to him. So because of that, in 2017, he filed a lawsuit. Now, of course, UPS denied these allegations, but most importantly, they said that even if he had experienced this discrimination that he claimed, it wasn't legally valid. So specifically what they said is that the 20 incidents of discrimination that Jason JESSUP had faced over the 2,261 days he had worked didn't meet the legal standard of pervasive discrimination. So to back this up, they cited a ruling by the Second Circuit, which said there must be more than a few isolated incidents of racial anonymity. Instead of sporadic racial slurs, there must be a steady barrage of opprobrious racial comments. So basically what they're saying in this case is that these 20 incidents of discrimination aren't enough to prove discrimination by a legal standard because it was over too large of a period of time. It has to be pervasive or a steady barrage, as they mention. And you can see this at the bottom here, the quote from the Second Circuit. And so because of this very high legal standard, it can be very difficult to prove discrimination, even if you're someone like Jason JESSUP, who's over his time working for UPS, faced 20 incidents at least of discrimination. So now we'll move into the third possible cause, and this is judges and the role that judges play in deciding discrimination cases and their success. The first thing that I want to look at is bias in judges, because this plays a very important role in how they rule on cases. So it's important to note first that everyone has bias, including judges. Like us, judges consume media. They're taught different things from a young age. They grow up in society just like us, and so they hear the same messaging that is often prejudiced. And because of that, they oftentimes hold biases like the rest of us. Additionally, judges in the US tend to be from dominant groups. More than 73% of judges are male, more than 80% of judges are white, and most judges are middle-aged or older. So these groups tend to hold more biases than marginalized groups. And because of that, they may be more likely to rule against marginalized groups, who are the ones who are often being discriminated against. Additionally, political affiliation plays a role in bias. So most judges are politically active before assuming the bench, before they become judges. And then once they become judges, political affiliation of a judge tends to mirror the party that dominates in that judge's state. And this is important because political affiliation plays a significant role in how judges rule on cases. So we're going to take a look at that in this next video. And this is looking at political bias in Supreme Court justices. It's a video from Now This World. And although they're talking just about Supreme Court justices, studies have shown that these trends exist outside of the Supreme Court as well. So this video is just less than 3 minutes long. And I also wanted to note that the first case that they discuss is a Supreme Court case called Burwell v. Hobby Lobby. The case itself isn't that important to the video, but just so y'all know, it was a case where the company Hobby Lobby argued a religious exemption for providing birth control to their employees.
The Hobby Lobby case voted by the Supreme Court may have gone just like you would have predicted. 5 justices appointed by Republican presidents voted along Republican Party lines, and the 4 Democratic appointees voted along Democratic lines. The same thing happened with voting rights and campaign finance reform. So does that mean that the US Supreme Court justices are biased? Well, based on recent studies, it seems they might be. One study out of Washington University in St. Louis showed that for the most part, justices vote in favor of free speech issues that are in line with the way they lean politically. Most guilty is Justice Thomas, a conservative who has voted with conservative free speech issues like corporate personhood 65.4% of the time. Likewise, he's voted for liberal free speech issues like women's rights only 23.1% of the time, a gap of 42.3%. That said, liberal justices like Ginsburg have also been found to vote for liberal free speech issues with disproportionate frequency. Another study out of the University of Chicago looked at the 20 most significant Supreme Court cases since 2000. They found that 98% of the time, justices voted along party lines, which is an alarming statistic, especially when you consider that Supreme Court bias is a fairly new issue. A study cited by the New York Times found that between 1790 and 1937, justices voted along party lines in only 1 case out of the 71 that they deemed important. Experts also point out that prior to the last 25 years, justices switching political leanings once appointed was not uncommon, the last instance being Justice Souter. They also point out that it's been more than 50 years since a democratically appointed judge consistently voted with conservatives. So why is the Supreme Court so biased now? Well, it may have something to do with the increased polarization of Washington. The current Congress is on track to become the least productive in history, and the judges are closely tied to these parties. Some may feel that they owe a lot of their success to the party that eventually appointed them, while others might be influenced by their surroundings. In the past, Supreme Court law clerks who work with the justices were balanced and nonpartisan. But over the last 9 terms, justices appointed by Republican presidents have hired Republican-leaning law clerks about 83% of the time. And Democrats have hired liberal-leaning law clerks about 66% of the time. These are just a few examples showing the current political climate in the Supreme Court, and they do indicate evidence of bias. Still, there have been recent exceptions, specifically the 2012 Obamacare ruling in which Republican-leaning Chief Justice Roberts voted with the more liberal side of the bench.
All right, so now that we've looked a bit at the role of political bias and bias in general, I want to move on to judicial selection. So before I go into the impact of judicial selection, I'm going to explain a bit about how judicial selection in different states can look. So there are three main types of judicial selection looked at in the study that I'll go into in just a second. These three main methods are election, hybrid, and appointment. So in election states, people vote for the judges, both for the initial appointment of the judge and also for their re-election. So for them continuing to stay on the bench. And then we have a hybrid method. So in this case, a governor appoints a judge, and then the people in the state vote for the judges continuing to be judges. So they vote on retention. The final type is appointment. So in the case of appointment, only the governor appoints and retains judges, and there is no election. In California, judges are elected. So if you're able to vote, you may have even voted for some judges. And then judges of superior courts, like the California Supreme Court and the Court of Appeals, are nominated by the governor. And the governor also appoints judges if there are vacancies in between elections. So I think it's important to look at how judges are appointed in your state or elected so that you understand the role that they can play. Additionally, judicial selection is important because it ultimately determines who becomes a judge, and who judges discrimination cases will absolutely affect their outcome. And we can see this through the impact of judicial selection on discrimination cases. So what we're looking at in the graph on the right here is the total number of discrimination cases brought versus the judicial appointment process, which is on the bottom here. And the reason why we're looking at the total number of discrimination cases is because this paper cited other studies that showed that discrimination cases are more often brought when people think they'll be successful, which makes sense. If people think that they have higher rates of success, they'll be more likely to bring discrimination cases. So the total number of discrimination cases can be indicative of the success rate. And as we can see based on this graph, states that elect their judges or have a hybrid system have consistently more discrimination cases brought than states that appoint their judges. And the same holds true for race and sex. States that appoint their judges have much lower rates of discrimination cases brought, and therefore likely lower rates of success, than states that elect their judges or that have a hybrid system. So it's clear that the way that judges are appointed, or the way that judges are selected, has a great impact on the success of discrimination cases. The final cause that we'll look at in success for discrimination cases is the system itself. So how the system operates, even if, for example, there is no judicial bias, and how the system itself can impact the success in discrimination cases. So what I'll be referencing for this section is an article written by Mark Gallanter titled "Why the Haves Come Out Ahead: Speculations on the Limits of Legal Change." So Gallanter in this article looks at two main groups of people. He calls them one-shotters or OSs and repeat players or RPs. So one-shotters are people that deal with the legal system infrequently. They're less knowledgeable about the legal system in general, and they tend to have fewer resources. So less money, less access to other resources such as time, those sorts of things. And in general, in employment discrimination, one-shotters are the employees. Now, on the other hand, we have repeat players, and these are institutions or companies in this case. They interact with the legal system often. They have tried a lot of cases in court, so they have repeated litigation on their side, and they also tend to be relatively wealthy and have more access to resources. Now, there's plenty of systemic advantages for repeat players, but the biggest is that they can what's called play for the rules. So playing for the rules is using the system to their advantage. And the way that they do this is through something called strategic settlement, which I've defined on the right. Now, strategic settlement is settling cases where precedent, which is judicial rulings that determine how judges rule in future cases. So settling cases where precedent will likely be harmful to one-shotters or the employees in this case, and litigating or taking to court cases where precedent is likely to be favorable. So when cases go to court, precedent is created, but when they're settled, there's no precedent created. And this helps repeat players have success in the long run and have the system work for them. Now, when employees obtain a settlement, they end up losing in the long run because no favorable precedent is established for them. And on the other hand, when repeat players take cases to trial, they create precedent that's favorable to them, so they're more successful in the long run. Judges often look to precedent to decide future cases. So when precedent favors repeat players or favors the employers, over time, this is accumulated to help the employers and ends up disadvantaging employees because of this strategic settlement and playing for the rules. Now, I know I've talked a lot about all the different issues with anti-discrimination cases and low rates of success and why this might be, but I also wanted to give y'all a little bit of hope and some resources because this isn't completely a lost cause. And there's plenty of organizations that are working to fight employment discrimination and help us move in the right direction. One of those is Project When. This is a nonprofit organization that's dedicated to researching, educating, and providing actionable resources focused on preventing and combating harassment in the workplace. So a lot of what they do is provide information for the public about employment discrimination. They provide information to employers about how to prevent employment discrimination before it happens. And they also provide information to employees about what to do if discrimination does occur. Another one, an organization that's doing interesting work is Project Implicit. Project Implicit has an implicit bias test that anyone can take to see what kind of biases they hold and they might not be aware of. So we talked about the role of bias in judges as well as in employment situations and how bias can play a very harmful role in creating situations of discrimination. And recognizing these biases is the first step in dismantling them and eliminating discrimination. So definitely recommend you go to that website and take that test and see what implicit biases you hold. And the last organization is the ACLU, or the American Civil Liberties Union. And this is a slightly more popular one, so you may have heard of it. A lot of what the ACLU does is fight legal cases. They fight cases all the way up to the Supreme Court in support of people's civil rights. So one of the cases that I referenced earlier in this presentation, Bostock v. Clayton County, actually consisted of 3 cases, and the ACLU was counsel for 2 of them. Even though it can be very difficult to gain equity through the legal process, and it's certainly not the only way to move towards justice, I still believe it's a really important tool that we can use. And the more cases there are won, such as Bostock v. Clayton County, the more precedent is created and the more that we can move towards finding justice. So I think although the law isn't the only tool that we can use, and there are certainly lots of issues, it's definitely one way that we can work towards finding justice. And the ACLU has been a big part in that. All right, so these are the resources that I used in my presentation. On the right, there's a URL that you can go to. On the left, there's a QR code that you can scan with the camera on your phone. And both of those will bring you to a Google Doc that's broken down the resources that I used by slide. So if you'd like to learn any more about any of these topics, there's plenty of more information that I wasn't able to include that's referenced in those sources. Additionally, I have the links to Project When, Project Implicit, and the ACLU websites all on that QR code. So if you want to learn more or check those out, I definitely recommend you scan that QR code or go to the URL. Thank you so much for listening to my presentation. That brings us to the end. If you have any questions, please feel free to put them in the chat. I would love to answer them. Also, on the right, I have included a QR code for the CCC Linktree. So from that QR code, you can follow our Instagram, go to our Facebook, check out our YouTube. On our YouTube, we'll be posting a recording of this, and we also have recordings of our other programs. Definitely recommend you check that out. Follow us on Instagram. We do some really cool work. So go ahead and scan that QR code and you can access all those links, like our email, our website, our Instagram, all that sort of good stuff.